All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 31st. We have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 bills on the docket, and we're going to start off with, is Delegate Carr here? Is that on the list today?
Oh, hold up, don't.
Sorry.
So that one's last.
Delegate Carr, you're up. Welcome. There you go.
All right, thank you so much, Mr. Chair. I know your mayor will appreciate being called up too, because she's on this bill as well. But good afternoon, distinguished members of the JPR Committee. Glad to be back here 2 days in a row. For the record, I'm Delegate Al Carr. I'm pleased to present House Bill 918 on behalf of the Montgomery County delegation. This is a local bill. It received a unanimous favorable vote from our House delegation, and hopefully the chair of the Montgomery County Senate delegation will convene you all to take a vote on it soon. It's intended to address an equity issue in cable and broadband service. Most people like me who live in Montgomery County, live in a single-family home or live in a townhome, we have a choice of broadband providers. If we're not getting good service from our cable TV and broadband provider, we can switch to a different provider. But people who are tenants who live in apartment buildings are often confined to a single provider because their landlord has an agreement. So that means they're paying higher prices and they're getting inferior service compared to people like me. So House Bill 918 would guarantee that tenants could have access to multiple providers. It mirrors legislation that has been on the books for decades in other jurisdictions in our region. In the delegation hearing back in December, we heard from witnesses, including tenants, tenant organizations, one of our cable companies, the former cable administrator for Anne Arundel County, and there was opposition from a couple of organizations representing landlords. The bill before you is the result of some good faith negotiations with AOBA. That is the landlord organization that is most familiar with the Montgomery County market. As a result, we made changes to the bill. They dropped their opposition to the bill. The FCC did recently rule on this issue, and to me that confirms the problem and the need to take action. And so this bill is still needed because the FCC ruling could be overturned or it could be reversed by a future administration. I'm going to also be sending you an amendment that would make it a statewide bill. If you really like this idea, you might want to consider just making this a statewide bill because there are other counties that could benefit. So I respectfully ask for your favorable report.
Excellent, thanks. I see we have a question from Senator Sidnor and Senator Cassidy, but let's finish up with the panel and then we'll take questions at the end. So, Madam Mayor, if you'd like to go next, and then we'll go to Mr. Losak. If you could come to the podium. Great. Yep.
Thank you. It's been a while. I've lost practice. Thank you for being here. I also want to say thank you to the mayors across Maryland. We are meeting today at the Maryland Mayors Association, and I'm glad to have the opportunity to be here. I'll be short. The City of Tacoma Park supports House Bill 918. As many of you know, in the City of Tacoma Park, we are about 50% renters and 50% homeowners. We have many of our residents who live in multifamily buildings, and so we support their ability to get access to these digital services. And as we are looking at under COVID and seeing the expense of digital services and the divide just getting greater, we support this so that we can stem that tide and make sure our residents have access to the full range of digital services. Thank you for your time today.
Good job.
Good afternoon.
Mr. Losak, if you could come up to the podium so we can catch you on the camera and both sides of the horseshoe can see you.
Thank you. Good afternoon, Senator and Chair Smith and Vice Chair Waldstreicher. Thank you all for having us today, and thank you for your leadership on all issues affecting renters. This has been an extraordinary year. My name is Matt Losak. I'm speaking today on behalf of the Vice Chair of the Renters Alliance Board of Directors, Chris Perry, who recently had surgery and cannot be here today. So if I sound like somebody else, it's because I am. I deliver this testimony on behalf of Chris Perry, who serves as the Vice Chair of the Renters Alliance, the first and only regional nonprofit dedicated exclusively to renter outreach, education, organizing, and advocacy. The Renters Alliance supports Bill 918, and we thank Delegate Carr for his leadership on this bill, which would allow and promote competition in the cable television market and accompanying broadband internet service for renters in Montgomery County, and we thank Delegate Carr for his leadership. Briefly, we are seeing more and more tenants who are unable to get digital access, cannot afford cable, cannot afford to pay the kind of prices that we're seeing from in apartment buildings where we have only one cable provider. I personally am paying over $250 a month just to have cable, internet access, and telephone. We are seeing more and more renters who are low-income, middle-income renters who simply can't afford it. And now, as you know, the way of modern communications and all things public policy and social are being driven by digital access. So there's more detail in our testimony, but as a courtesy for putting us up first, I'll be brief and simply say thank you. We support this bill wholeheartedly, and to remember that nearly 40% of Maryland residents now live in rental housing. Thank you.
Excellent. Thank you very much. All right, we'll go to questions from the committee. We'll go to Senator Sidnor and then Senator Castley.
Thank you, Mr. Chair. If I may, Delegate, I understand exactly what you're trying to do, but the one question that I have, I remember negotiating contracts like this. I'm wondering, how does this affect contracts that are currently, that maybe an apartment developer or something currently has with these cable companies? I mean, has there been any thought about those kind of situations?
Thank you, Senator. That's a really good question. I do not know the answer to that question, but I'd be happy to research that and get back to you. I do know that Anne Arundel County already has a law like this for about 15 years, District of Columbia for 20 years. So I'm sure that issue has been solved. I just don't know the answer off the top of my head.
I mean, I guess I'm thinking, if you're going to do this, if you have contracts that are currently valid, maybe it is something that would be done at the end of the terms of those contracts. I mean, something, because you don't want to have a law that goes against, I mean, something, an agreement that's already in place.
Yeah, that's
just a thought.
That's an excellent thought. Thank you so much.
Yeah, hi, Delegate.
Good afternoon.
I'm concerned, I realize there's a local bill, but property rights sort of transcend that, and I am concerned about the section that prevents the landlord. It's just, landlord cannot prohibit or otherwise prevent a cable television company from accessing a dwelling or unit for the purpose of constructing, installing, or servicing a cable television system. That language, it just sort of treads on property rights there of the landlord. Is that language also the same language you said was Anne Arundel County already had this bill, this law?
Thank you, Senator. So yeah, so Anne Arundel County has a similar law. So does the District of Columbia, and this applies to companies that are franchised. So in Montgomery County, we have Comcast, Verizon, and Astound/RCN. Those are the three franchisees. So this dovetails with the franchise agreement between the county and those providers. So they already have obligations under the franchise agreement. Arwen Bain is here from Astound, so she might have, a better, a more detailed answer on that question than I do, because they're already operating under this in multiple jurisdictions.
And this applies to all landlords, regardless of size, is that?
It applies to 5 units and above.
Right. Yeah, and again, is that a provision that's in the Anne Arundel County Code as well?
Whether it applies to 5 and above?
No, the prohibition on the landlord.
I'd have to reread the Anne Arundel County Code, but my understanding is in Anne Arundel County, every landlord has to get a license, and the renewal of their license is contingent upon the landlord giving their tenant access to all of the franchised cable providers, who are the broadband providers.
Okay, but this is just really strong language, prohibit or otherwise prevent a cable television company from accessing the unit, I mean, kind of give them free run of the building for installing. I mean, I could see a landlord or a cable company deciding to take the shortest route and running cable as they choose, whereas a landlord may, for example, say, no, you're bringing cable in this way, it's going to cost you more, but I don't want to deface the hallway, this is how we run it in this building, and if you want to run it here, you can run it, but it's got to come up through this chase, through this conduit or whatever. And I'm just concerned that we limit a landlord's ability to say, no, this is my building.
Yeah, thank you, Senator. So Arwen Bain, who signed up to testify, she represents one of the cable providers in Montgomery County, and, they deal with this issue every day, so she would probably be a better person to answer that than I do. But in Anne Arundel County, where they've had a law like this for 15 years, those kind of issues
Yeah,
just
that's why I was curious.
haven't
whether
come
this-
up.
Sure, and and time does prove, right? That's why
Yeah.
I was curious whether this specific provision here, whether this language mirrors Anne Arundel County or not, but you weren't sure if that's.
I'd have to reread that, but I know the idea is the same. I don't know if the language is identical. I'd have to get back to you on that.
Thank you, appreciate it.
Yeah, thank you.
Thank you, Mr. Chair. Good to see you, Delegate.
Good to see you.
I had sort of the same questions that Senator Castley just had. So let's assume you have a 10-story condominium and you have one tenant up on the 9th floor that doesn't want to use Verizon, he wants to use a new cable company. Wouldn't your bill enable the new cable company to come in and run conduit up the outside wall of the building or run it down? There's no limitation on where they can run it. I assume that when the building was built, it was built with cable in chases that accessed each unit. Is it not possible for a new cable company to use the same cable conduit as is already there? Or would the new company have to run new conduit to the unit up on the 9th floor?
Thank you, Senator. That's a great question. And it's probably a question you might want to direct to Arwen Bain, who has signed up to testify, because
Okay.
she represents one of the cable companies. But my understanding of what typically happens is, the landlord and the cable company, of which there are only 3 in Montgomery County, or 2, depending on where you are in the county, have to come to an agreement about where to place the infrastructure. Is it in a common telecom closet that's in the basement that serves the whole building, or is there like a wiring room on each floor that equipment has to be placed in, and then you just reuse the coaxial cable to the actual unit? I think it depends on the building and the provider. But the hypotheticals about chaos or building damage just didn't happen in the 15 years it's been in effect in Anne Arundel County.
Okay. And the bill refers to landlords, but in the case of a condo that's pretty occupied, the landlord at that point would be the condominium association, I assume. right?
Well, the bill applies to buildings, not condos, but apartment buildings that have 5 or more units.
It says residential rental property, okay.
Yeah.
But,
So if that property owner had 5 or more units, in the same place, then it would apply to them, but it wouldn't necessarily apply to condos in all situations.
although you could have a condo unit owner who's renting his condo to somebody else, and then all of a sudden. but-
That's true, and if he had 5 units that he was renting out, then it might apply.
I see, okay.
Yeah.
All right, good. I'll ask the other witness. Thank you.
All right, thank you.
Thank you, Delegate. Just a quick question. There are some benefits from living in a very rural area like I do. One of those is the fact that we are extremely limited on broadband carriers. We actually have one, right? So, but my question is, we do have some areas that have more than 5 units. So I was wondering how this applies, because we do have like a provider of satellite.
Sure.
Right, so how would that how would that apply versus satellite versus the actual cable providers?
So, first of all, it's a local bill, so it only applies in Montgomery County.
Oh, I
And-
know, but you said that you were going to provide us with amendments that would be a statewide bill if we wanted to.
Sure.
Look at that, so that's why.
Second of all, it applies only to franchisees. So satellite providers do not use the public rights of way, so they're typically not franchisees. What might happen if you had a building that had only satellite but not cable, that might allow for those tenants to now have a choice between satellite and cable.
Okay, thank you.
Right, thank you.
Is Mr. Bain?
Good afternoon. I'll read my statement. If there are questions, I'll definitely be happy to answer them. Let's see. Thank you. My name is Arwen Bain Cosby, representing Astound Broadband, formerly RCN. Astound Broadband maintains and operates its own fiber-rich network, offering competitively priced high-speed internet, streaming TV, and phone. We have been a part of the Montgomery County community for years, providing award-winning service and 24/7 customer support. Astound Broadband is committed to 3 fundamental tenets: partnership, choice, and technology, whereby we partner with property owners and developers in order to provide a choice of services for commercial and residential use. We welcome the opportunity to serve more Montgomery County citizens who are currently not able to access our services due to restrictions imposed by some landlords. Astound Broadband supports HB 918 for the following reasons. First, creating an environment of choice will foster a competitive market for quality products, pricing, and overall service. Second, the bill provides an incentive for multifamily landlords to remain engaged, invested, and active in the action required to address barriers to equitable access and choice. Finally, the FCC rulings do not go far enough to address the gap between inaction and purposely entering exclusive agreements. Multifamily residents may have access to some level of connectivity, but choice of service provider along with products and pricing options that meet their needs are likely limited. A competitive market with the representation of a full suite of providers is what allows equitable access for every multifamily subscriber to have a say in what type of service they receive. Having the choice to disconnect and find something different, better, or more affordable is only possible when there are multiple providers available and who are each competing to earn customers by providing the best quality service.
Briefly conclude. All right.
Okay. Concerns about physical integrity of property make it understandable that there may be questions. Most of that is addressed in the standard access agreement.
Excellent. Thank you very much. All right, we'll go to Senator West for a question.
Thank you, Mr. Chair. So I want to come back to the line of questioning I started earlier. Can 2 cable companies use the same cable? In other words, once the building is wired for the internet, can 2 different companies use that same wiring system? Or would a second company have to install a separate parallel wiring system?
That will be situational based on a few factors. One is what type of cabling it is, whether it's fiber or coaxial, or if it's Ethernet, what type of equipment is connected at either end of that line. And then if there is room for the second provider who's coming in after the fact, for them to place their own demarcation equipment, the nodes, the taps, the other things that make it specific to that second provider to be able to transmit over that cable.
Well, this bill as drafted doesn't seem to differentiate between one system or another system. They're all treated identically,
Yes.
right? So let me just read you a portion of the testimony of the Maryland Multifamily Housing Association, because I want to get your response. I don't know if they're going to be here to testify, but I'd like to hear, as long as you're at the podium, what you have to say.
Yeah.
They say, the bill allows any tenant to request cable service without approval from the owner of the building. Installation of cable service in a specific unit will require access to adjoining units to run cables and hardware. This could potentially lead to chaos and in effect gives the tenant control of the leased premises and even various areas of the property and removes that right of control from the housing provider. There's no limit to the amount of construction that could occur in any given community. These projects take weeks or months, depending on the size and complexity of the project. The property owner must have the right to approve the method of installation, cable routes, drilling, visible components to units and exterior buildings that affect the aesthetics of the building. So that's the gist of what they had to say. So what's your reaction to all that?
My response to that is that in general, and in fact, I'll say always, what happens for us to determine if or how we can bring service to a building is first to conduct a survey. That's with the permission of the property owner manager. We get access to all of the common technical spaces, telco closets, trash room, wherever those chases are, wherever the cabling exists today. And we build a scope of work description that will allow us to run lines that are also compatible with our network. That same scope of work is what's built into that access agreement that I mentioned, which is then under the review, revisement, and approval of whoever the owner manager is for the property.
But that sounds like you're working cooperatively with the building owner. And this bill appears to say, even if the building owner doesn't like what you're proposing, you have the right to do it anyway.
I cannot imagine a scenario where we would be able to effectively pull off the type of construction that is required without the coordination with the owner manager. The way that I look at this language is that it will compel that owner manager to partner with us. We really have no benefit to hijack some portion or some building to, fit that need.
Okay, thank you for your answers.
It's funny, you were thinking more along the lines, the same thing with Senator Cassidy, along the lines of cable, and that's almost a less offensive or intrusive method, but I was thinking, the first thing that came to mind was like a satellite dish. What if I wanted satellite TV? Does this mean that as the owner of the property, I could not prevent someone from putting a satellite on the side of my building or on my roof? And it does say, may not prohibit or otherwise prevent a cable company from accessing a dwelling unit for the purpose of constructing, installing, or servicing a cable television system equipment if the tenant has required, or requested rather, cable television system or service. It seems that it would be a complete bar from the owner of the property from obstructing in any way the construction of my satellite dish if I wanted it.
Understanding that this speaks to the 3 franchise providers, and that, leaves the satellite providers out. I am familiar with some buildings that do not allow satellite dishes, or they restrict them to only one side of the building or only the roof of the building. There's some kind of concert there about how that gets done from an aesthetic standpoint, or honestly from a logistics standpoint, but I've never worked for satellite, so I can't fully speak for it.
So I'm trying to figure out what part of the bill says that it only attaches to the 3 major providers. It just says cable television system does not include a facility that serves 49 or fewer subscribers, or only subscribers in one or more multiple dwelling units. I'm just trying to figure that out. Is there?
Delegate Carr may be able to speak to that
Okay.
better, but I do believe the word franchisee exists somewhere in that document. I cannot remember where. Sorry.
Okay, no worries.
Okay.
Thanks. We'll go to Senator Watson, then Senator Cassidy.
Yeah, thank you. Thank you very much. Sorry I came in a little late. So this actually has been done in other jurisdictions where there was a single provider and then they switched to multiple providers, correct? So when they've switched to multiple providers, and I came in on the tail end of discussion where we were talking about wiring and having access to other properties and those things, is the cost of that infrastructure totally borne by the landlord?
It's totally borne by the provider in our case. We are going to show up, conduct that work, do the restoration work, install all of our infrastructure at no cost to the owner-operator.
Okay, and then the provider would just get their money back based on a number of subscribers who opt into their service?
Correct, and in our case, that's always with the understanding that we're not setting minimums or maximums in terms of number of subscribers guaranteed or offered by the owner-manager.
And in the cases that this is already done, and you said with pretty much certainty that there are no satellite providers?
I can't say that. I will say that satellite offers a certain level of service that may or may not be available with the actual franchise providers.
Okay, I was just asking because there is an aesthetic piece to this thing. When you look at a property and you got satellites all over the place, and I don't know how many times you can split a satellite signal to go to, 600 or so units if that was the case. But thank you very much.
You're welcome.
Do you do work in Anne Arundel County also?
We just purchased a network there, formerly known as Broadstripe, under the WOW brand. So Astound RCN purchased that, and we will begin operating there actually now.
So you haven't actually started, you wouldn't be able to tell us how things are going in Anne Arundel County?
Yes, I manage the existing contracts that were signed by Broadstripe. We have several contracts there that are allowing us to provide service in a general state where we just have been given permission to do the construction, install the equipment, and provide as a level of service to the residents. It's basically an easement allowance.
Yeah, have you had instances where the landlord, well, how do you do that? You go and consult with the landlord? How does that work? How does it operate?
Absolutely. We're always going to go to that property owner manager, the landlord, whoever it is that's the decision maker there. Sometimes it's an asset manager. You usually have a gatekeeper of some sort that you have to get through. And then to coordinate with them about, again, access for survey, who is allowed to review and then ultimately sign a contract. But there are no terms there that would not be agreed to by both parties.
Right. So in Anne Arundel, the landlord apparently has the ability to say, here's where you can run it, here's how you have to run it, that kind of stuff.
Absolutely.
You can't just come in and say, hey, the law says we can run this, get out of the way. We're going to put it.
No, that is definitely not our experience.
Yeah,
Yes,
Okay.
and the same in the district.
thank you very much.
This is very helpful. Thank you very much. Thanks.
You're welcome. Have a good day.
So with that, that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and Mr. Greenfield. You're up.
Thank you, Mr. Chairman, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association, here in strong opposition to House Bill 918. For many of the reasons Senators Castley and West referenced, I would ask that you read or reread page 2, line 18. It completely takes the housing provider, the owner, out of the decision-making. There is no partnership between the cable operator and the housing provider under that provision, and making it statewide makes it even worse. Let me also speak to these ordinances that the sponsor spoke of. You know, they were both enacted in 2006, well before, a year before, the FCC initially took any position on exclusive access, which is what this concerns. I would also say, in response to Senator Castley's questions to the sponsor, those ordinances are different. And I'd encourage you to look at the DC ordinance, section 34-1261.01, which allows for a landlord to require conditions and architectural controls to protect property and the well-being of tenants. It also requires the cable operator or the tenant to bear the entire cost. The cable operator also must indemnify the landlord for damage. The Anne Arundel County ordinance similarly requires compensation. A cable operator must indemnify. If you look at this bill, specifically, it speaks to a landlord being able to get compensation that is competitively neutral and non-discriminatory. I don't know what that means. And that's very different from the ordinances that the sponsor enacted in 2006. The other last point I would raise is in February, the FCC did issue new guidance on this following an invitation in September, and again, affirmed their position about this issue of exclusive access. I would just lastly say, Mr. Chairman, that it is troubling that one state would legislate this for one county in one state when we have the FCC that has stepped in to address this matter. We come strongly in opposition to this bill. It takes away significant property rights.
So under the FCC new regulations, does that require a landlord to allow different cable companies to provide access?
It does, and it's a much more partnership-based focus versus an absolute prohibition under this bill.
So under the FCC regs, if I'm in an apartment building with 20 apartments and everybody has provider A, and I say, well, I want provider B, then the landlord has to work with the provider to somehow get me access?
Correct. Under this bill, though, what is sort of nonsensical is that you could be one unit in one building and request service And whether a cable operator comes or not, under this bill, you got to let them in. And now the question becomes, will a cable operator actually come in to wire one unit? I suspect they wouldn't.
Well, this doesn't require the landlord to put that cable in. If the cable operator's not going to come, they're not going to come.
Correct.
Okay, but this doesn't require them to come. We're still back to the same issue of landlord controlling the property enough to work with the cable operator to say, here's where you're running it, here's how you're running it. I want an indemnification provision for any damage you cause before, during, and after installation.
That's
the
correct.
big issues. Thank you.
Thank you. I'm curious, you had mentioned, I guess, the portion of the statute about indemnification. I'm surprised because it seemed like that would work to the benefit of your organization and clientele, right?
It would. I don't see the bill, though, doesn't say anything about indemnification. What I was referring to, I'm sorry if I was unclear, is the ordinances that the sponsor referenced that were enacted in 2006, before the FCC first stepped into this issue, require indemnification by the cable operator in the event that there's damage. That's not in this bill.
It is. It's on.
Oh, is it? I'm sorry.
Page 2,
I'm getting
lines
confused.
29 through 31. The landlord may require that a cable television company indemnify the landlord for
you're right.
damage. I mean, that's to your organization's benefit, though,
Correct,
right?
correct.
Okay, I
That
just
is,
wanted to make
yes. I'm
certain.
sorry, I was confused. You're
Okay.
right. You're right,
All
Senator.
right.
Thank you.
Thank you, Mr. Chair. Let me just give you a hypothetical. So, two tenants on the 8th floor of this apartment house want this particular service, and the cable company concludes that the cheapest way to do it is to run a cable on top of the lawn in front of the building to the front door, and then up the outside of the building to the 8th floor, and then into the 8th floor lobby and along the ceiling of the 8th floor corridors to those two units. Would the landlord, under this bill, have any opportunity to say that's not acceptable? It's going to deface the appearance of the building. You have to do it a different way.
Not under my reading of the bill.
That's what I was reading too. Thank you.
All right, seeing no further questions, thank you very, actually, we got one more, Senator Sidnor.
Just to piggyback off of the senator's questions, I mean, even with it not being in the bill, am I to believe that a cable company can just come onto a property and just install the cable however they want without entering into some sort of an agreement as to how the cable is, or whatever, is going to be laid within the building?
Right, but that's not under this bill. It almost creates an exemption where you don't have to. But yes, under normal circumstances, you're right, Senator, that would have to be. There's typically partnership-based agreements with the cable company to allow for service to take place where the rights of entry and those kinds of things are permitted. That's not outlined in this bill.
Okay, thank you.
All right, seeing no further questions, thank you very much. And with that, that'll conclude the hearing for House Bill 918. We'll now go back to House Bill 174, Delegate Lehman, and I know that the staffer's here, so welcome.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and esteemed committee members. My name, for the record, is Charles Tuttle. I'm speaking for Delegate Lehman, who is indisposed at the moment due to the floor session. I'm asking for your favorable report for HB 174, a bill that requires a landlord to demonstrate that he or she is in compliance with local rental licensing laws in order to proceed with a motion to evict. The bill does four things. Number one, it says a landlord who files an eviction case based on a tenant's failure to pay rent cannot do so without demonstrating that the property is in compliance with the county or municipal licensing requirements of the jurisdiction where the property is located. Second, the bill establishes that during the trial, the landlord has the burden of proving to the satisfaction of the court that the rental property is licensed in compliance with or exempt from any applicable rental property requirements. Third, it allows the landlord to present electronic copies of the license to satisfy the burden of proof. And finally, it prevents the court from entering a judgment in favor of a landlord who fails to demonstrate that the licensing requirements have been met. This bill is needed because residential rental property licenses provide a level of assurance that a property is both safe and habitable. The 6 largest counties in Maryland have residential rental license laws, as do 17 municipalities, including some such as Harvey de Grace, Salisbury, and Westminster, that are located within counties that do not require licenses themselves. As for amendments, as originally drafted, the bill did not allow temporary or provisional licenses to be used as proof of a license. However, after researching this issue extensively, my office learned that only PG County issues provisional licenses. Those were created as a response to a staffing shortage in the licensing office and are only good for 90 days or whatever the unit, or whenever the unit is inspected, whichever comes sooner. Another amendment allows a tenant or a court to examine the property's lead inspection abatement certificate at trial. Another changes the standard for landlords to show proof of a valid license from a preponderance of the evidence to the satisfaction of the court. The overall premise of the bill is simple but powerful. Landlords who fail to comply with local rental licensing requirements on the front end cannot evict tenants who they have no legal right to be renting in the first place. The bill also provides for a remedy to those landlords. Go to the jurisdiction where the property is located and obtain a rental license. Then and only then can the landlord move forward with an eviction case. I urge a favorable report.
Excellent. Thank you very much, Senator West.
Thank you, Mr. Chair. So we passed a bill along the same lines. It was Senator Hedelman's bill. It was Senate Bill 563. And Delegate Lehman had a cross-file of that bill, House Bill 703.
Yeah.
The 703 never moved. This bill instead moved in the House. Would Delegate Lehman have a problem if we conformed this bill to the Senate bill that we passed after much work a couple of weeks ago as a consensus bill?
Thank you for your comments, Senator. You're referring to Senate Bill 563, correct?
Yes.
Yes, so the only difference between that bill and this bill is that HB 174, this bill, additionally permits a tenant or the court itself to examine the validity of the property's lead inspection certification at trial. So I believe this is something that Delegate Lehman's witnesses and her feel adamantly about. And I believe that if she would want to make compromise for that, that she'd be open to talking with you about it, or
Okay.
the committee.
Thank you, Mr. Chairman. You're doing a great job.
Thank you, Senator.
So I just by way of some explanation, Delegate Lehman and I, Delegate Lehman had been working on this issue for a number of years and had introduced this bill in sessions prior, and had just focused on failure to pay rent. And that's what this bill does. It just focuses on failure to pay rent, whereas she is the cross-file of 563 also. And that includes failure to pay rent and tenant holding over and breach of lease. But the House did put on this, I think, very important amendment related to lead paint. And so it is certainly not inconsistent if we were to move, we already moved that 563, but if we were to move this one too, it seems complementary. So I just wanted to put that out there. Thank you.
Thank you.
Excellent. Thank you very much, Senator Hedelman. All right, seeing no further questions from the committee, thank you very much.
Thank you.
All right, excellent. So that'll conclude the hearing for House Bill 174. We'll now go on, Delegate Weibel, you're here. I know you've got your duties to attend to on the floor, so I want to make sure you're next.
Yes.
I have Delegate Weibel with House Bill 873.
Thank you, Mr. Chairman. It's good to be with you and honorable members of Judicial Proceedings. House Bill 873 is a simple local bill. All it does is sets the sheriff's salary to 90% of the state's attorney's salary, and it removes the sheriff from the Salary Study Commission. Very simple. I ask for a favorable report.
Excellent. Thank you very much.
Thank you.
All right, have a good one.
Thanks, you too.
All right, with that, that'll end the hearing for House Bill 873. We'll now move on to House Bill 521, and I think we have someone here for Delegate Peña-Melnick. Is Jessica? Yeah. Oh, okay. Mr. Kemmerer. Okay, excellent.
Thank you, Mr. Chairman, Vice Chair Waldstreicher, distinguished members of the committee. For the record, my name is Hannibal Kemmer, and I'm here to urge a favorable report on Delegate Peña-Melnick's bill, House Bill 521. This bill is very limited in nature. It permits people to petition the courts to shield their failure to pay rent cases, and it only applies to the period from March 5th, 2020, when the governor declared a state of emergency, through January 1, 2022. So it's limited in scope. It's only for people who suffered economic losses due to the COVID-19 pandemic, and we urge a favorable report. I'd welcome questions.
Excellent. Senator Castley.
Do you have any idea how many people this affects or could affect?
Yes, the fiscal note says that between the beginning of the pandemic and last December, it was 530-some thousand people. Obviously, probably more now, but those people would be eligible.
Okay, so it applies to, just trying to read it, do a quick read. So this applies to tenants, but not to, this is not, it's not applied to for repossession, failure to pay rent that resulted in a money judgment. So it does not apply to those. Oh, unless it was satisfied, okay. All right, so.
Right, so in order to be eligible, you had to have paid the money.
I do have paid the rent.
Yes.
Okay, thank you.
My pleasure.
Thank you for being here.
It's my pleasure.
I wonder if you could talk about why this is important and kind of what the downstream effects are of having this on your record.
Sure. So we cited a Law Journal article in the one-page testimony that basically says that tenants are thrown into unemployment by COVID-19 are already facing non-payment eviction in some states, including Maryland. When eviction moratoria are lifted, many more will join them. If records of these cases remain unsealed, a present COVID-19 eviction will haunt the tenant until 2025, 2030, even beyond. Eviction's a civil offense. It can result in a single isolated instance of non-payment. There's no reason that courts and legislators should allow these single incidents, legitimate or not, to dictate a tenant's housing prospects for another decade. And that's the downstream effect that we're talking about here. Most landlords, if they see an eviction filing for the foreseeable, for as far back as time immemorial, will not rent to those tenants. And so it really makes it difficult for people to get housing.
Thank you.
Thank you.
All right, seeing no further questions, thank you very much.
Thank you, Mr. Chairman. May I be excused?
All right, with that, that'll conclude the hearing for House Bill 521. We'll now move on to House Bill 650 with Delegate Brooks. Welcome. I know they're all back on the floor. Are they on the floor now?
They are.
Yeah, that's right. Okay.
Good afternoon, Chair, Vice Chair, and committee members. For the record, I'm Kimberly Shiloh, Legislative Director to Delegate Ben Brooks, here today on his behalf to present HB 650, Execution on a Judgment for Child Support Arrearages for Workers' Compensation. HB 650 merely specifies that 25% of net recovery on claims for workers' compensation is subject to an execution on a judgment for child support arrearages. Currently, the statute does not explicitly define whether workers' compensation indemnity benefits can be attached to child support orders, and if so, whether or not there's a cap to those withholdings. That leaves injured workers and child support enforcement authorities, as well as workers' compensation claims personnel, left to interpret the ambiguous law, which leads to inconsistent results. HB 650 merely offers some clarity in an otherwise ambiguous statute in determining which benefits can be garnished. This clarification aligns workers' compensation benefits with personal injury recoveries. For these reasons, we ask for a favorable report.
Excellent. Thank you very much.
Thank you.
No questions from the committee. There you go. With that, that'll conclude the hearing for House Bill 863. We'll now move on to Delegate Terrasa with sorry.
That was 650.
That was 650, sorry. And we'll now move on to Delegate Tarassa with House Bill 863.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. Thank you for the opportunity to present House Bill 863. For the record, I am Brooke Scoville, Delegate Tarassa's Chief of Staff. She's on the floor. So the problem this bill addresses, because of a series of regulations and departmental guidance stemming from current Maryland Code, criminal defendants are being denied the right to a fair trial because they are unable to question the results of the state forensic lab, and in some cases are unable to have expert witnesses testify at trial. So the background is the Maryland Department of Health is responsible for the licensing of forensic laboratories. Health General Code 172A04 states that a forensic laboratory shall hold a license issued by the Secretary before the forensic laboratory may offer or perform forensic analysis in the state. An unlicensed lab may be granted a letter of exception by the Secretary of MDH to perform limited forensic analysis if it meets the exception requirements and regulations adopted by the Secretary. So MDH took it a step further, though, is through its Office of Healthcare Quality and promulgated regulations that require individuals who perform forensic analyses but are not affiliated with a licensed laboratory to obtain a letter of permanent exception. However, MDH also went a step further than that and requires this letter for individuals who are merely reviewing results or conclusions of an original analysis. This essentially means that state lab employees can perform analyses on forensic evidence, but those who do not work for a state lab must seek a letter from the state to even review the work of the state lab. This creates a problem for defendants seeking to have an expert review analyses performed by a state lab in preparation for trial. And the problem goes even further. Some trial courts have interpreted the regs to mean that in order to testify in court on behalf of a defendant, the forensic expert has to obtain a letter of permanent exception. In other words, these judges are interpreting the law and regulations to mean that whether an expert has a letter of permanent exception is a threshold question. Rather than the trial judge making a determination whether an expert is qualified, some judges feel their hands are tied by these regulations and they cannot move forward in deciding if the witness is qualified from their perspective. So this may in part stem from a 2012 OQHC letter which stated failure to obtain a letter of permanent exception may affect the criminal court's decision when considering the admission of forensic experts' opinions, interpretations, and conclusions. The bottom line is that MDH should not have control over whether or not an expert can testify against them. It might make sense for the department to have a say in who comes into their labs and does original forensic analyses on items in MDH's custody and control. It has an interest in and an obligation to protect those items. However, MDH does not have a legitimate interest and in fact has a conflict of interest with respect to whether the defendant's experts can review and question their conclusions. It therefore does not make sense to require defendants' experts to have to request permission from OQHC to review reports and testify in court. And part of the problem is, from my understanding, or from Delegate Ross's understanding, these letters of permit exception are rarely, if ever, granted. Ultimately, the effect of the current law and set of regulations is that there are no individual chemists currently permitted to review crime lab reports in the state of Maryland. And this means no one may independently challenge the drug evidence presented against them in court. So what HB 863 does is fixes this simply by prohibiting the court from requiring an MDH letter of exception for an individual to testify in a criminal proceeding who is reviewing the data, opinion, interpretation, or conclusion of another expert witness or forensic laboratory and is not handling the physical evidence. Originally, the bill was drafted to prevent MDH from requiring this letter of exception for an expert who is merely reviewing a report. However, working with the State's Attorneys Association, Delegate Tarassa amended this in the House to prohibit the court from requiring this order for a non-state lab-affiliated expert to testify in court. And the State's Attorneys Association has withdrawn their opposition to this legislation. We have support from the Public Defender's Office and chemist/forensic scientist Ben Streifel, a constituent of Delegate Tarassa's, who brought this matter to our attention. I respectfully urge a favorable report.
Yeah, you went fast.
I'm
so
sorry.
That's all right. You said, what about the State's Attorneys Association?
Oh, originally
Originally, they were opposed?
Originally, they were opposed when we were requiring the Secretary of the Department of Health or when we were prohibiting the secretary from requiring the letter. But that caused some concern because they were worried that it would prevent a non-state lab affiliated expert to be able to testify in court. So we amended it so that it's just the judge who gets to decide.
So that the what, I'm
The
sorry?
judge, the trial judge would be able to decide, we would prevent the judge from requiring the letter.
So then they withdrew their opposition.
Correct.
Thank you.
All right, seeing no further questions, thank you very much. I think you've got one more bill.
Yep.
So that'll conclude the hearing for House Bill 863. We'll now move on to House Bill 1147.
Okay. Good afternoon again, Chair Smith, Vice Chair Waldstreicher, and honorable members of the committee. Again, for the record, my name is Brooke Scoville, Delegate Trost's Chief of Staff. I'm here to present HB 1147, which requires that virtual meetings of a common ownership community, in other words, cooperative housing corporation, condominium, or homeowners association, provide participants a reasonable opportunity to participate in the meeting, and that they have equal access to any available chat function. So you may recall a bill passed by this committee last year, which authorizes the governing bodies of common ownership communities to use virtual means as a way to conduct formal meetings. The legislation was sponsored by the Honorable Chair Smith, passed the Senate and House unanimously, and took effect on June 1, 2021. While these types of meetings may have begun as a result of necessity during the COVID-19 pandemic, it has become clear that they will likely remain a regular option. Such virtual meetings are a convenient and effective way for people juggling work and family life to have the opportunity to attend. However, if they are used as a standard practice and not just during a public health emergency, we want to make sure that they resemble an in-person meeting as much as possible. This is one of the topics that was discussed as part of a common ownership community task force set up by Delegate Marvin Holmes during the 2021 interim session. The issues that people raised included the inability of community members to fully participate in virtual meetings in meaningful ways. For example, many COC boards would block community members from using the chat feature even if they were using it themselves. Many times these same COC boards would mute all community members and not give them the ability to unmute, and thus they were prevented from participating in the meeting in any meaningful way, asking questions or even objecting if they observed a violation like lack of quorum. And they can't even say if they are unable to hear the board or see documents that are supposedly shared or ask where the agenda is. The goal may not have been to prevent any participation, but rather for the ease of running the meeting. However, without any ability to participate in the meeting, community members' presence on a Zoom or other virtual platform is no different than merely watching a meeting on TV. And not similar at all to an in-person meeting where, of course, order needs to be maintained to run the meeting, but people can still ask questions or pipe up if they can't hear or object to the lack of quorum, et cetera. This issue is something that various bodies have been grappling with across the country. So what HB 1147 does is, first, if the COC board has the chat function on for themselves, then members should also be able to access that function. And second, community members must generally have the ability to unmute themselves. Of course, we've all experienced or heard of an experience when someone becomes disruptive in a virtual meeting, which can also be said for in-person meetings. That's why HB 1147 provides for the person conducting the meeting to mute or remove a participant after giving them a warning if they interfere in the ability to conduct the meeting. Just as a board can have someone removed from an in-person meeting if they become so disruptive that they are interfering with the ability of the board to conduct the meeting. So HB 1147 is a simple, straightforward bill that just ensures fair participation and transparency for all the residents living in common ownership communities. I urge a favorable report.
The existing law provide for recording of the meetings? Is that mentioned at all?
We didn't change anything that was passed in the bill that went through last year, and it just provided for electronic means for the meeting. I don't remember, we don't have anything in there about recording it, I don't think.
All right, seeing no further questions, thank you very much.
Thank you.
Thanks. All right, that will conclude the hearing for House Bill 1147. We'll now move on. I see Delegate McComas is here, so we'll go with House Bill 1169. Delegate McComas, welcome.
Thank you, Mr. Chair, Mr. Vice Chair, Delegate Lee, Senator Castley, Senator Sidnor, Senator Huff. I've served with all these folks, and Senator Watson. So hopefully I'll get a favorable report for SB 1169. This has been over to to the Senate JPR several times, but it never got a vote. Well, I'm hoping, and so I attached the list for 18 and for 19, and it was a major majority in the House. Well, the bill has been recently amended, which requires the Maryland Department of Health through Maryland CHAMP, which is the Child Abuse Medical Providers, to provide each health occupations board that is authorized under current law to take action against an applicant, a licensee, certificate holder, registrant, or permit holder who knowingly fails to report suspected child abuse as required by current law, with a list of generally recommended courses on the obligation to report abuse and neglect and the identification of abused and neglected children. Each board must, 1, post the information required for a prospective student to enroll for one or more of the recommended courses prominently on the board's website, 2, provide information about the courses to specified healthcare professionals at the time of license renewal, or 3, advertise the availability of recommended courses in the newsletters or any other media published by the board. These provisions do not apply to a board that requires licensees, certificate holders, registrants, or permit holders to obtain CLEs, continuing education on the identification and recording of abused and neglected children. Child abuse experts know firsthand that the impact that such abuse of our children has on society as a whole. More importantly, they understand how imperative it is to have appropriate and up-to-date training to improve the outcomes for child victims. Training for mandated reporters to recognize the abuse and then how to report what is observed is the next best thing to protecting our most valuable assets, our children. CHAMP weighs in on HB 1169, saying that they are willing and able to search for and review potential training materials. Even more important, CHAMP is willing to modify and update materials to meet reporting requirements in Maryland as needed. This is the most exciting part of their support. They are willing to modify and update materials as needed. We cannot ask for a better support for this bill and ultimately the provision for greater protections for our children. Finally, Maryland Health Department Board of Physicians clearly supports HB 1169, stating the board is happy to provide information about these courses on its website as required by this bill. Please enter a favorable report for House Bill 1169. The other thing I would just like to say is I do have an updated position paper from the Board of Physicians, which basically they indicate they support the bill. The first one was a letter of information where they had some concerns, but then with the amendments, they were very happy, and I did work with Dr. Wendy Lane, who is the head of CHAMP, as well as the Maryland Board of Physicians, to craft the amendments that are in your packet. So hopefully, if there's anything that I can do that you need more information about this bill, it's a simple bill, but the simple in the legislature can become so complex. So I hope that we can, and I'm certainly willing to do whatever it takes to make this pass, and there's not a cross file. So I will beg Chairman Clippinger to accept any changes that you might make. So are there any questions, or? I ran over here, so that's why I'm out of breath.
No, I appreciate you bringing the bill to us, and we'll work on it. Questions from the committee?
The amendments are.
We'll get them for the voting
I believe we
session.
provided a reprint for you as well. And if you don't, I know my aide was, made sure that she got that over to you, but like most things with the, I'm a paper person. So I love making Xerox copies. So if there isn't anything you need, let me know. Because we did provide the original amendment with the reprint as well as the voting, but the voting was from the House was before we ever dealt with this amendment. And this seems to take care of all the issues that the Board of Physicians had. And the biggest complaint was that they absolutely did not want to get into the business of having all these folks that provide educational materials coming at them, and they have to deal with that. So this is all will be the latest and the greatest.
And right now, Dr. Lane is on the State Council for Child Abuse and Neglect. So she's like, she keeps up with this. She eats, sleeps, and thinks about this constantly. So, and she is part of, I think, the School of Medicine.
Excellent. That won't be necessary. Our council will have the reprint ready for the voting session, so we'll have all the information.
Okay,
ready.
well,
Yeah.
but if there's anything, I'm glad to get on my broom and come over here and do it.
Absolutely, 100%.
Okay, thank you all very much.
All right, hey, thank you very
Take
much.
care.
I appreciate it. All right, good to see you, by the way. All right.
Good to see you all.
Okay, all right, so that'll end the hearing for House Bill 1169. We'll now move on to Delegate Wells with House Bill 551.
Hello, Chair Smith, Vice Chair Waldstreicher, members of the Judicial Proceedings Committee. For the record, my name is Matt Kramer. I'm Delegate Wells' Chief of Staff, and I'm here to testify on House Bill 551 on the delegate's behalf. House Bill 551 would require landlords to give 90 days' notice of rental increases of more than 4% to their tenants. Current practice dictates tenants give their landlord 30 days' notice before moving out of their rental unit. By giving tenants 90 days' notice of rental increases, it will give the renter, in essence, 60 days to decide if the new price is one they can afford or if they need to find new living arrangements. While this is not the overall solution to the rental affordability crisis we are facing in Maryland, this is one small step we can make to help curb evictions. My office receives calls, emails, and texts on a daily basis from nearly every county asking us for relief in their rent. While we have plenty of work to do in this respect, giving our renters across the state additional time to decide on the best living arrangements for them is the least we can do. It is with this that I ask for a favorable report on House Bill 551.
Excellent, thank you very much. We've got Senator Watson.
Yes.
Just one question. The bill looks extremely simple, but I'm struggling to understand why the opponents talk about rent control. Can you explain
was originally a rent stabilization bill, and it has been heavily amended to just become a rent increase notice bill.
Just a notification bill?
Yes.
Okay, thank you.
Simple enough, all right, thank you very much.
Thank you so
Excellent.
much.
So that'll end the hearing for the proponents. We'll now hear from the opponents, and we'll have Mr. Wiggins.
Good afternoon, Mr. Chairman, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. I want to point out that my testimony at the top says favorable with amendments, but I know in JPR I have to sign up with opposition to speak. I can't speak if I'm favorable with amendments. And I did feel compelled to speak, as Senator Watson pointed out, the bill was heavily amended in the House, and this is actually the first hearing of the text that you've got in front of you. So this text did not have a hearing in the House. And, you know, as a written testimony points out, we are requesting respectfully that the bill be amended from 90 to 60 days as a floor for a notice of a rent increase, and in turn strike the 4% and just make it any increase. And with that, take any questions.
Most landlords that I see use the standard Maryland Realtors form. What is that? It does have a requirement in there in the standard form for notice. Do you know what that is?
I do not. So I have not seen the Maryland Realtors form, but I'm sure that I can reach out to the Maryland Realtors and look at that form.
Thank you.
Just curious, why 60? And what do most landlords, tell me how most landlords plan when they are planning a rent increase?
Yeah, so it's a little different. It's not, as you may know, not as simple as just picking a number out of a hat, right? So they have to analyze market trends, the impact that the market's having on them, right? I mean, we just had an inflationary period where the cost of doing business went up for housing providers. And during that time, my housing providers dealt with things like 2 years of rent freezes, right? And so, you know, some of those negative consequences that came from those local policies. So a housing provider will analyze the market, analyze the trends, analyze the impact of the cost on them, and we think 60 days is a fair notice. You know, as the proponent noted, I think he said in practice the tenant would give 30 days of a non-renewal. So a 60-day time frame would give 60 days, your rent's going to increase, 30 days to decide if that's something you want to do, and then 30 days to non-renew if that's something you want to choose. Now, that is one situation. That's not necessarily industry practice. I think it varies by landlord, and this is certainly something that can be negotiated in a lease. Again, 60 days here would be a floor. The parties would retain authority to negotiate their lease as they see fit.
Right. I mean, I guess I'd like to know if, and I don't know if you survey your members all the time, kind of if you have any sense from the bulk of your membership, how they do it. And given that we've gone through a tumultuous, time over the past 2 years, that's sort of a unique circumstance, but I'd just sort of be interested in, whether they plan a year out. Because, they're doing budgeting and I'm sure they plan pretty well ahead. So I'm not really understanding why the 60 and 90 days is that much different.
So I'd be happy to survey them. I would say in the reality that we're in now, anybody that could predict the budget in a year now would be, I think, it's a special situation considering the inflationary costs that we've been dealing with for the past 2 years since the beginning of the pandemic.
Sure, but they're doing longer term planning here. And I guess the other question I had, I mean, I don't know, I know my office has definitely been hearing from people whose rents are going up exponentially. And so there is a lot of concern out there. And just, I think that the amended version of this just requires notice.
Right, and again,
kind of a measured
we don't oppose the
approach.
notice, we're just talking about the difference in the floor.
Right.
And we are comfortable with striking the 4% as well, and just making it any
Any increase. Yeah. Okay, I actually think that's a good suggestion. All right, thank you.
If we could just have Delegate Wells give us some feedback on, I'd like to hear what she thinks about because no, it doesn't matter, 4%, whatever, any increase, 60 days. If she could give us some feedback as to what, unless if she's amenable to that, that'd be helpful for our discussions.
I can certainly take it back. I know the conversations that we have had is that her concern is we already have to give a landlord notice 30 days before moving out of a unit, and 30 days is not enough time to decide if you can afford your rental increase or find appropriate living accommodations. So I think I'm happy to take it back. I think the 30 days would be tough, especially for a lot of our constituents.
But he said 60.
Or 60 days.
Yeah.
Well, 60 days, yes, but if you have to give 30 days notice of if you're leaving or not, that is in essence only 30 days to decide. And I think that's why we went with 90.
If you,
Doesn't landlord have to give 60 days?
it's the
to
other way
terminate the
around,
lease?
yeah.
So,
Okay.
yeah.
Like I said, I'm definitely happy to take it back.
Excellent.
But
Okay.
those are just conversations we
Thank
had.
you very much. Thanks. All right, with that, that'll end the hearing for House Bill 551, and I believe the hearings for the day. We go back, we've got, 2 minutes to get back onto the floor. We've got, what type of a voting list do we have?
It's about 15 bills, I think.
Are they concurs?
They are. So we do have 2 concurs that we should do right now.
Okay, we've got 2 concurs that we should vote on right now, and then we've got,
And then we have about 15 bills in the voting list, and they're bills that we want to conform to the Senate version or adopt the House version. No, we don't want to do.
okay.
So this is a concur report for Senate Bill 279. We did the House bill yesterday, so I recommend a concur to match up with what you voted on yesterday. So it replaces the phrase "money received by the aggrieved party" with the term "restitution." Yes, a concur would be identical to your vote yesterday.
Seconded. Everyone's okay? All right. Is that it?
Yeah.
All right, so that'll end the voting session and the hearings for this afternoon.